Good afternoon. I'd like to welcome all of you to the benefit forum hosted by the Business Healthcare Group. We have a very large contingent of participants, not only in the room, but also even more so that are participating virtually. And so the name of the program this morning is Increased Fiduciary Risk, Johnson & Johnson Risk. I've had a number of different discussions with John Parliament concerning this issue, and we thought it had arisen to the point where we should bring it forward to our benefit or our member employers. Now, what you'll find is that the vast majority of participants this morning are BHCG member employers. We have not opened this up as a Delivering Value Series Symposium. So we're doing the Delivering Value Series Symposium on May 14th on obesity, and that will be opened up to the general public under, again, the Delivering Value Series Symposium. Next slide, John. So the speakers this morning are, first of all, Paul Page, Chief Legal Officer with Navitas Health Solutions. John Parliament and myself have spent a lot of time with Paul in negotiating master service agreements and also administrative service agreements between BHCG and Navitas and then half of our member employers. Second speaker is Stephanie Argentine, Chief People Officer and Head of Legal Affairs for Centivo. Thank Stephanie for joining us. She's made a long trip to get here, so thank you very much. Third speaker, and John is going to actually open it up. It's John Parliament, shareholder, Reinhard Warner, and then Dura. And the Business Healthcare Group has had and I don't use this term lightly, but a long-standing partnership with John. John has negotiated every master service agreement that BHCG has in place, and also all of our administrative service agreements. And we have a number that we have teed up that we're going to be working on for the remaining portion of 2024. And then we have Dave Ostendorf with us, Chief Actuary, Centivo. Dave is going to be the moderator this morning. And then obviously myself, and I'm the Executive Director of the Business Healthcare Group. And Dave, do you want to talk about how we're going to handle questions this morning?
Sure. So we're going to have John talk a bit about the issue and give an overview of what's happening in both the J&J lawsuits and sort of the bigger issue of fiduciary risk. We'll ask Steph and Paul to just give a quick reaction to what they hear from John's presentation. And then we'll break into a panel discussion. I'll give the speakers a question to sort of chew on a bit. And then we'll look to all of you both in the room and on the phone to go ahead and give us your questions. I know this is one of those really meaty issues that is going to have questions all the way from just basic content all the way until what does it mean for me and how does this involve in my personal life. So sort of everything is fair game. We've got three great speakers who are willing to take on sort of anything that you want to throw at them. So we'll have a pretty wide open discussion. The expectation is that a good chunk of this session really is a Q&A kind of format as opposed to us talking at you. Even though we have brilliant speakers here, it's probably better to get at what your real issues are. So that's the approach we'll take. Just from a logistics standpoint, I'm just going to make sure that everybody on the line is on mute until we have the question and answer side. I will give fair warning to all the people here in the room that the lights that are overhanging you are relatively sensitive. So side conversations may get picked up pretty easily. So it's just make sure that you do that. And with that, I will turn it over to John and let him dive in.
And one other point too, so we are scheduled to go from 9 to 10:30. And in our preparation session, it became quite evident that in all likelihood, we're going to go right up against that 10:30 time. And if we should end up going over, our speakers have been gracious enough to agree to spend some additional time with us. So with that, John.
All right, thanks, Jeff. Thanks, everyone who's here in person and virtually. Very excited to walk you through today's topics. We're going to talk about kind of an ERISA refresher on fiduciary status. HIPAA would be an interesting topic too, but so used to talking about HIPAA. And the first maybe 10 slides or so are not really new law at all. It's kind of a refresher. In other words, ERISA has been out since 1974. It's celebrating its 50th anniversary here. And sometimes it's just helpful to get a little bit of a refresher on what ERISA fiduciary duties are out there, how they can apply to employers, how they apply to people in the benefits area. We will then go into a discussion of some recent health plan litigation, i.e. applying those fiduciary rules to the health plan context. We'll talk about the actual claims in the Johnson & Johnson complaint, and we'll talk about action steps and strategies more as part of the panel discussion. In terms of ERISA and sort of how we got here, ERISA was enacted in 1974 in response to perceived bad actions by plan sponsors and others, primarily with regard to retirement plans. Health plans are definitely regulated from an ERISA perspective, but they were sort of an afterthought. And this is kind of a side topic here. When I was a younger lawyer, my mentor was a great lawyer, Scott Ingroff, and Scott started doing benefits law in 1968 before ERISA came into effect. And I said to him, so what caused Congress to do this? He said that some of his devious clients at that point in time, his bad actor employer clients, they would have a 10-year cliff vesting provision for their retirement plan. They'd make people work 9 years, 360 days, and then they'd fire that person. And they'd say, you know what, if you want to reapply for your job next week, show up next week. Everyone showed up next week, they reapply for their job, and then they got their job back. But critically, they never hit that 10-year cliff vesting provision because they were fired before they hit their 10 years. You can't do that anymore. That's a violation of ERISA Section 510. But that's an example of, kind of the things that some of the more devious employers, I guess, were doing. I don't think Scott cared, by the way. He's a good guy. As long as they paid their bills, he was probably fine with it. But that's, again, just kind of something that was one of the impetuses here. All right, so what does ERISA do? Lots of different requirements out there. Some are more administrative, Form 5500 filings. Some are more substantive, some non-discrimination provisions like that ERISA Section 510. Others are mandatory things. You have to cover certain benefits from an ERISA perspective. Who enforces this? The U.S. Department of Labor primarily enforces ERISA. IRS does some kind of parallel provisions. CMS, Center for Medicare and Medicaid Services, has some similar enforcement authority too. In terms of the fiduciary duties that ERISA imposes, when Congress was trying to write ERISA and trying to figure out what kind of duties should be imposed upon folks, they looked to trust law. So they went back in time. Trust law is old law, goes back to England, kind of the Middle Ages. The concept that if you are a fiduciary, if you are kind of overseeing some benefit for somebody else, like if you're an executor of a will, you should establish rules for yourselves and make sure that you are properly, administering that will, properly administering that trust. And as the law has kind of built up over time, the courts have held that this is probably the highest known standard under the law. So Congress wanted to make this very, very difficult standard in order to ensure that the people who are administering these plans are following kind of the highest conduct which is out there. And so it's a very high standard. Does your ERISA covered plan, if you're sitting here listening today, does your ERISA covered plan have a fiduciary? Absolutely. Every plan has to have a named fiduciary. That's right in ERISA. You don't have an option. You can't check a box and opt out. Somebody has to be a named fiduciary of every single ERISA plan. You also have to have a plan administrator. The plan administrator is the person or committee or entity who is supposed to serve as kind of the point person for ensuring compliance with these various rules. By the way, this is kind of a side point too. Sometimes we have clients who just name the employer as the fiduciary, or the document is just silent about who it is. It's just the company is the fiduciary. That is not our typical recommendation, because if you just are kind of silent on it, or you just name the committee, or if you just name the company, the courts have generally said that at that point, because of your silence on this topic, the highest entity within the company becomes the fiduciary of the plan. Normally, that's a board of directors. And this came up several years ago with regard to Enron. Everyone remembers kind of the failed energy company. Enron had just named the company as the fiduciary of the plan. That meant the board of directors. Board of directors never actually saw any of their plans, and it created liability after the company crashed. The board got sued in this space. And the board said, we don't know anything about these plans. We don't administer them. And they said, sorry, look at the plan documents. You're stuck with this liability. So again, lesson is don't be the Enron, I guess. We always encourage our clients to say, okay, who within the company is really going to be hearing, appeals, who's going to be filling out the Form 5500s, who's going to be taking these actions. So again, a little bit of a side point maybe, but helpful. Yeah. In addition to that, certain people can be fiduciaries based upon their actions. And this is kind of a flow chart here. The main takeaway here is if you have discretionary control or authority over plan assets, you're probably going to be a fiduciary. So for example, if you are, hearing appeals in the health plan context and the disability context, something like that, you probably have some control. And you also have authority with respect to the plan. So you're probably going to be a fiduciary in that context. In addition, and this is an important point too, sometimes when I describe these concepts here, clients get pretty nervous because they're like, well, wait a minute, if I'm a fiduciary and I want to increase someone's co-payment or increase the deductible under the health plan, does that mean that I'm engaging in a breach because I'm not acting in the best interest of plan participants and beneficiaries? And you can see how that would be a possible argument. Because, if you're thinking about it from their perspective, every time you increase a copayment from $10 to $15, that sounds like it's problematic. It sounds like you're working against them. And so ERISA has this concept called a settlor activity, where if you are wearing your settlor hat as opposed to your fiduciary hat, and this is a lawyer's attempt at graphics, I guess, here. So take it for what it's worth. But if you're acting in a settlor capacity, then those fiduciary duties drop away. So you don't have to act in the best interest of plan participants and beneficiaries. You can say, sorry, we're going to double the deductible this year. We're increasing the maximum out-of-pocket payments. We're doing X, Y, Z in terms of a plan amendment or plan termination. So there is some flexibility there when you're wearing your settlor hat as opposed to your fiduciary hat. Your fiduciary hat would be plan administration activities, implementing amendments or terminations, hearing claims, hearing appeals, things like that. All right, so let's dive into fiduciary liability here a little bit more. This point is always a little bit scary, but it needs to be said. Fiduciaries can have personal liability for losses that flow from their breaches. So by personal liability, we mean personal liability. So if you are the fiduciary for your health plan at your company, and if you breach your fiduciary duties, you could lose your house, you could lose your car. You've been saving up money for your kids' college. Sorry, that's gone now. So you can have personal liability. And again, that's another thing we like to emphasize, because then what we usually try and do is we usually try to have the company provide some kind of liability, some kind of indemnification, step in, because most of the time, someone in the benefits area is not all that keen on losing their house, losing their car, things like that. So again, if this is all set up correctly, normally the employer, the plan sponsor, kind of steps in, provides some kind of backstop as long as you weren't being egregious in terms of your activities there. The other point to note too is, while there are lawsuits where people have had real personal losses, most of the time you have to have like egregious situations, like stealing plan assets, absconding with funds, things like that. That's where you tend to see some of the true personal liability. Typical people in the benefits area, within a corporation, they don't usually get sued for personal liability, but it's out there. You can also have liability for co-fiduciaries if your failure allowed the breach, if you participated in the breach, if you knew about it, you concealed it, if you didn't take any action to remedy a breach, there can also be liability there too. Oof, that's terrifying. All right, let's move into kind of the core fiduciary duties which are out there. Exclusive benefit, prudent expert, plan adherence, some disclosure rules, other ones here too. Exclusive benefit. In general, fiduciaries have to act for the exclusive purpose of providing benefits to plan participants and beneficiaries and defraying the plan's reasonable administrative expenses. Actions taken with an eye toward the plan sponsor's business goals or other goals of third parties may violate this duty. And this does come up on occasion. We work with some like health systems who sometimes have questions about like steering their own employees to use their own providers. And the question becomes, how much can those providers charge? Are you kind of engaging in what's called a prohibited transaction when you work in that area? And this, so it does come up primarily for me in that healthcare provider space. So it's a complicated space. If you're a typical kind of widget manufacturer, you probably don't run into this kind of issue. In general, be impartial in terms of how you administer the plan. Whether it's the CEO's appeal that you're dealing with or the janitor's appeal that you're dealing with, you should administer it in the same manner. Prudent expert, you're supposed to use the level of care that a prudent person knowledgeable about such matters would use in that same situation. That's a tougher one there. Basically, our advice is if you don't have that expertise, then you should hire outside experts or educate yourself. And if you are hearing appeals, which is a fairly common activity still, if you get involved in appeals, that is where you may need additional expertise. You can imagine health plan appeals where, it's a complicated medical condition and you have to figure out if it's experimental, is it investigational? Most of the time, people in the benefits area don't have that expertise. We usually recommend relying upon third-party medical review firms in that context, or your TPA who may be able to provide that kind of advice too. So again, just keep in mind when you're wearing your fiduciary hat that you are supposed to be knowledgeable, basically be an expert. We also advise folks about substantive prudence versus procedural prudence. And the concept here is that when you are administering your plan, you always really want to focus on procedural prudence, making sure that you have set up the plan, that you follow all these different steps, that you kind of walk through your process. This is how we hear appeals. Here's who hears the appeal. Here's our third-party experts. Kind of do it that way. If you manage to have a good procedure in place, then you're unlikely to be challenged in a lawsuit from a substantive perspective. In other words, it becomes very difficult for a plaintiff to kind of prove that you reached the wrong result. If you said this is experimental, this is investigational, here's why we think it is this, it's hard for a plaintiff or a judge to kind of second guess you if you've kind of set everything up from a correct perspective procedurally. So what are those procedural prudence kind of factors? Look at the factors which are relevant to the decision-making process, go through the necessary fact-finding steps and background information, look at what kind of expertise and knowledge you need. When necessary, consult with outside experts. Look at the different relevant criteria, document your decision, put it in writing in terms of what process you followed. I have some clients who are really good about this. They have monthly meetings or quarterly meetings with their benefits committees. They take minutes, they put everything in writing. That is absolutely great from a procedural due diligence perspective. I have other clients who have no committee, nothing formal, who's deciding this? Well, let's go talk to Joe, and next week we'll talk to Sally, and it's just kind of hodgepodge. That is not the gold star standard. So again, kind of follow that procedural process. That's a lot better. Plan adherence. All of your actions must be in accordance with the plan document, with the summary plan description, other documents under which the plan operates. If you are unhappy with a decision under the SPD, you should modify it. That's our best kind of advice there. Occasionally, we will, sit in on a client appeals, like health plan appeals, and it'll be some kind of heartbreaking situation where you're like, oh my gosh, I can't believe that the plan is going to deny the situation. And if you don't like that result, then just change the plan, just modify the SPD. Don't do an exception. Don't say, hey, we know what the plan says, but we're going to ignore what the plan says and then approve this particular claim. That's not the proper process. You're kind of violating your procedural due diligence there. Duty to monitor. You're supposed to monitor all these processes. You're supposed to monitor your service providers. In theory, you're supposed to monitor TPAs and PBMs. Difficult for employers to do as a practical matter, but you're supposed to be monitoring folks out there. There's also these prohibited transaction rules, which say that you can't use plan assets to pay a party in interest unless you meet an exception to those prohibited transaction rules. For example, the fees must be reasonable. You must have a written contract in place with those vendors, et cetera. So, and this is an important point, that last point on that slide, because these prohibited transaction rules really are the basis that the Department of Labor or perhaps a plan enrollee can use in future litigation, like a Johnson & Johnson kind of litigation, where they could say, you know what, plan sponsor, you were being imprudent. There are plan assets, which are my participant contributions going into the plan. You had a fiduciary duty to make sure that those plan assets were spent wisely. You had a fiduciary duty to control the expenses associated with those, and you failed to do that, and that is a prohibited transaction, would be the argument there. So again, this is an important point there. All right, let me pause for a second because now we're going to jump into the actual health plan litigation. Stephanie, Paul, I don't know if you guys had any comments to any of that. No? Okay, good. Sometimes I joke that plans should monitor all their service providers except their attorneys. So no need to monitor us. We're all good. No, but no, in theory, it's really monitoring everybody. So, all right. Health plan fee litigation. So kind of bringing it back down to the Johnson & Johnson situation, must health plan fiduciaries manage the fees that the vendors are paid in the health plan context? And the answer is yes. With regard to plan assets, for example, participant contributions and amounts held in a trust, or perhaps amounts which should have been held in a trust, you have a fiduciary duty to monitor the fees that those service providers are paid. And the Department of Labor has a 2015 publication, Understanding Your Fiduciary Responsibilities Under a Group Health Plan, and they say exactly that you have to make sure that you understand that the fees which are being charged are reasonable, that you're getting an acceptable level of services with respect to those plan assets. Probably less of a risk for what I call pure employer funds. So if you had a plan where the employer paid 100% of the cost of the health plan, 100% of the cost of the prescription drug plan, I would argue that none of those are plan assets because none of those are participant contributions. There's still some ways that those pure employer funds could become a plan asset. But generally speaking, the ERISA is not all that concerned if employers waste their own money. That's fine. Presumably employers are smart enough not to waste their own money. ERISA really is hyper aware of participants' money being wasted. So that's kind of the main focus there. Excessive fee litigation in the retirement plan context is prevalent. There's literally thousands of cases in the retirement plan area. In the health plan area, it has been rare, it has been sporadic. When it's occurred, it's usually been focused on lawsuits against the TPA or insurer, not the employer or plan sponsor. And there have been more cases, I'd say in the past, 10 or 15 years than in the previous 10 or 15 years before that. Some recent examples: in 2017, the Department of Labor sued and then settled with MagnaCare. MagnaCare was a TPA. The allegation was that the TPA violated ERISA by charging plans an undisclosed markup over actual amounts paid to providers. So in other words, the claim was that if a provider charged $1,000 to see John for some kind of medical visit, that MagnaCare charged the plan $1,100 and then kept that $100 difference as additional revenue. And it's interesting. I have seen this. There's a big TPA down in Illinois that I question whether they do this right now. I think there's some concern that they might be doing this right now. So in other words, this is not a random, oh my gosh, no one else in the universe does this kind of process. I think this actually might occur with some frequency in terms of that extra charge. 2019. Another lawsuit, the Depot Inc. versus Caring for Montanans. The claim was that the insurer, this was a fully insured situation, charged extra fees, then used those as a kickback to local chambers of commerce to encourage their members to buy the insurance policies. That kickback process happened to violate Montana law. And the Ninth Circuit agreed that that was problematic from an ERISA perspective also. Throughout the 2010s, if you're interested in reading about a TPA that really got beat up, poor Blue Cross Blue Shield of Michigan, they've had to pay out hundreds of millions of dollars, it might be over $1 billion by now, back to their employer clients who have self-funded group health plans, because Blue Cross Blue Shield of Michigan didn't have language in their contract supporting the fees that they were charging. Similar to that example involving MagnaCare. Basically, they were just charging extra fees, which were undisclosed under the contract, and Blue Cross Blue Shield of Michigan has had to pay a lot of money.
John, can I ask a question?
Yeah.
And who were those fees being
Paid to?
Yeah.
So great question, Jeff. So in this Blue Cross Blue Shield of Michigan, it was employers who were bringing those claims against the TPA. The money went back to the employers. Now, when that money goes back to the employers, those employers probably have to figure out what the plan asset portion of it is. So if the employer was paying about 80%, employees are paying 20%. 20% of it, if they got $100 million back from Blue Cross Blue Shield of Michigan, 20 million of it would be a plan asset. The employer could not just take that 20 million. The employer would have to use it to benefit plan participants and beneficiaries, provide extra benefits, reduce costs, things like that.
So were any of those funds being paid to the broker consultant community?
I'm not sure about that. The question is, well, everyone can probably hear, but the question is, were any of those funds being paid to the broker consultant community? Not 100% sure.
Okay,
Yeah.
thank you.
Yeah. And again, if you look at some of these examples, they're really interesting, but they're more employers suing the service providers as opposed to employees suing the employers for not monitoring the service providers. So that had been kind of the trend. And interestingly, some of the,
in that example, the way for folks to think about it is these were employers that were exercising their fiduciary responsibility.
Right.
And going after monies that should have been kept within the plan.
I think that's a great point. And, by the employers in this situation, like beating up on Blue Cross Blue Shield of Michigan, to kind of beat up on them for a second, by the employers engaging in that activity, monitoring what the service providers are being paid, monitoring, making sure the fees are reasonable, that kind of protected the employers, I would say, from lawsuits against them by the plan participants. In other words, by the employers kind of being proactive here, they probably reduce their fiduciary risk in terms of participants suing them.
They
Yeah,
also had standing, which is going to be a thing we'll talk about in a second.
absolutely. No, great point, Steph.
Too many lawyers in a room. It's like we're all sitting down. What are you doing?
Right, exactly. Let's see here. So other, kind of developments here. This caught everybody's attention. Last year, there was a plaintiff side law firm that started taking out ads on, I think it was Facebook and other kind of social media, targeting employees of PetSmart, Target, State Farm, saying basically, hey, are you a current, PetSmart employee who has participated in the company's health insurance plan? If you were, you may have a legal claim. And nobody really knows exactly what the Schlichter Bogard law firm is doing here, but the speculation is that they're trying to do something similar to what's going on with Johnson & Johnson, where they're trying to find plan participants and then bring some kind of claim against the plan sponsor saying, Target, PetSmart, whoever, you mismanaged your health plan, you caused us to pay too much, et cetera, et cetera. So again, the new lawsuit is not one of these that where there was this kind of ad going on, but that kind of implies that if they do find plaintiffs here, that we could see some additional action there on that side of things. All right, other recent developments, February 2024, Erie County on the East Coast there sued the diabetes drug manufacturers and the PBMs, CVS, ESI, Optum Rx, over what they allege was an insulin pricing scheme, saying that there were high costs that self-funded group health plan had to pay for insulin. And again, that's kind of the plan sponsor taking the action, not the plan enrollee suing the plan sponsor. Also in February 2024, the Johnson & Johnson lawsuit, J&J was hit with a sophisticated, detailed complaint from an employee who lives in Madison, Wisconsin. The basic claim is that the plan has been mismanaged, and how the plaintiff is trying to prove that it was mismanaged really focused on the high cost prescription drug claims, which would naturally be paid under the plan. And what the plaintiff's firms did, I think this is an interesting and kind of good idea from their perspective, is they went through the cost of the drugs, which are under the health plan, figured out what those drugs were supposed to be paid at under the health plan. Interestingly, with all the new price transparency data, which is now out there, I think it's going to make it easier for plaintiff firms to get access to this data. We in the employer space are thinking of this, well, this is really helpful data for the plan enrollees. The plan enrollees will know what charges everything costs. This will be really good for them. But if plaintiffs' lawyers can get access to it too, employers are maybe not so excited about that. It kind of cuts against it. Now, the law is the law. I mean, it is what it is. But it's an example maybe of an unintended consequence that I wasn't personally thinking of, when Congress started enacting these price transparency laws. But it is what it is. We're kind of stuck with it. And so here the plaintiff is basically going through all the different drugs. There's hundreds, thousands of possible drugs out there. And they're looking for high cost drugs, like the one that they mentioned here is, I think I'm saying it correctly, Obagio, where the plan had allegedly agreed to pay $10,239 for a 90 days supply of the generic form of that drug. Supposedly, that generic form would be costing about $40 to $77 at a local grocery store or pharmacy. In other words, if the plaintiff had walked in to the local grocery store and said, hey, I need this generic drug, can you fill it? It would have cost the plaintiff $40, $50, something like that. If the plaintiff presented their prescription drug card, it would cost the plaintiff $10,000 for that same drug, is the claim. And the complaint goes through a whole bunch of drugs that are like that, saying that, hey, all these different drugs have a markup of about almost 500%. Johnson & Johnson, how could you have done this? Another important point here too is that all these were paid through a trust, through a VIVA trust. That's a little bit unusual. Most self-funded plans don't have trusts, but Johnson & Johnson did. When you have a trust, basically everything which is under that trust becomes a plan asset. All of it becomes subject to those fiduciary duty rules we were talking about before. So that, again, kind of increased it. The complaint also attacks the process by which the J&J PBM, allegedly ESI, was hired. They said that ESI really uses spread pricing as opposed to transparent pricing. The complaint goes out of its way actually to praise Navitus. Paul, I don't know if you kicked in $20 or anything. Yeah.
We did not contribute at all, but we definitely appreciate the publicity. It was great.
Yeah. It's a very nice shout out for the kind of transparent pricing PBMs like Navitus. So the complaint, now, again, don't get me wrong, I'm not saying that you have to use a transparent pricing PBM. I don't think, the law is quite there yet, unfortunately for Navitus, but you could see maybe kind of a trend where it's easier to defend transparent pricing as opposed to spread pricing, where the kind of pricing is a little bit unknown, from an ERISA perspective. J&J, we think, will have some good defenses here, primarily perhaps on standing. It's unclear if the plan enrollee actually paid for anything here. If she didn't actually pay for one of these, outrageously priced $10,000 drugs, maybe the plan enrollee won't really have any ability to support the lawsuit. I've talked to others in this space too. They've said that sometimes what happens is the PBM is forced by contract with the drug manufacturer to offer a lot of drugs, including high-priced ones, but then the PBM will steer individuals to use the lower cost drug. So it could be that nobody within Johnson & Johnson really was paying $10,000 for a $50 drug, or it could be that they were. Again, this will be fascinating to see where it goes with that. There has been some additional kind of back and forth. And again, March 2024, the Johnson & Johnson lawyers really focused on standing. In an April 4th, 2024 response, the plaintiff's lawyer said, we think that the plaintiff was harmed because the amount that the plaintiff paid in premiums and out-of-pocket costs was inflated by J&J's conduct. In other words, they're saying, even if it's negligible, even if she only paid, 5 cents more per year, she's going to have standing because of your mismanagement, was the basic allegation there. Interestingly, the complaint also went out of its way to attack consultants and brokers as having a financial bias here. It cited to media reports that consultants act as gatekeepers and demand commissions. Talked about one particular consultant. Again, this is kind of vague. It doesn't seem like it was Johnson & Johnson's consultant. They seem to be citing news reports about other consultants out there, about how sometimes those consultants will, in the RFP process, that employers go through this RFP process to try to find the best vendor at the most reasonable cost. And what the allegation here is that the consultants and brokers act as kind of gatekeepers or blockers. They basically say to the PBM, hey, if you want to participate in this RFP, if you're trying to get, J&J's business or GM's business, whoever it is, you have to agree to pay us an additional amount. You PBM are going to pay us $1 per prescription, $2 per prescription, something like that, as sort of a, the complaint would phrase it as a kickback. I'm sure that the broker community would phrase it as a commission, this is how they're getting paid. But from an employer perspective, that is kind of a quandary. If you are relying upon your consultants and brokers to give you honest advice, best advice of, hey, who are the best PPMs that are out there? Who are the best TPAs that are out there? How should we be evaluating this? And if they are receiving commissions kind of behind the scenes that you don't know about, that raises a problem from an ERISA perspective. So I can see how brokers and consultants are going to be nervous about this, and it could, eventually cause employers to maybe crack down to have those fees be disclosed, to take other actions in that regard. And then, let's see here. And then at that point, I think that we are, Dave, up to kind of the panel discussion here.
John,
Yeah.
could you comment on the very last
Oh, yeah.
quote there on the CAA price
Yeah.
transparency
So-
rules, because there may not be individuals familiar with
Yeah.
the CAA.
So yeah, good point, Jeff. The last question I have here is, will the CAA price transparency rules help? The Consolidated Appropriations Act from December of 2020 instituted new disclosure rules for various entities, including brokers and consultants, where brokers and consultants are supposed to disclose their compensation, their commissions, at least at kind of a high level. And it may be, kind of general and maybe sort of a formula. But yeah, there are supposed to be additional disclosures that brokers and certain consultants are providing to employers right now. I don't know if you've seen those or not as employers. If you haven't, it might be a good idea to ask your broker or consultant about it. Just say, hey, I heard that the CAA has no new disclosure rules. Can you disclose your compensation to me? Yeah. All right.
As we get to the Q&A point, I'm going to actually ask Steph and Paul just to give a sort of quick reaction to what you just heard, and I'll dive into some specific questions. But Steph, in reaction to kind of John's layout here and thoughts about what it means for all of us?
Yeah, maybe just two high-level reactions. The ERISA and the fiduciary duty content was helpful as a reminder. For me, I tend to think about it as really two parts: loyalty and prudence, and kind of, who we're acting for, and then how we're carrying out those duties. So, much more detail about it. But for any of you that are struggling with, oh my God, that was so much, to kind of make it into those bigger buckets might be helpful. I think the other thing is I'm having flashbacks to a job I was in 2007 to 2010, when this was big with retirement and setting up the retirement committee. And at the time, there were independent fiduciaries for hire, that you could actually bring in an expert to come in and take on some of that fiduciary liability and analysis on your behalf. So those were kind of just two. So that was, I think there's a lot of flashbacks here to kind of what we seen in retirement years ago. So yeah, go ahead, Paul.
Yeah, I think the thing that I would reiterate is the importance of the process that you mentioned. And that's that we don't like to just rely on the people we hired to do the work we hired them to do. But I don't think we can just hand it off and assume everything will be done just fine without any oversight or responsibility. And that's the hard part, is really figuring out where that level is and what level of oversight to do, because you can't micromanage people. You don't know when you don't know what they're doing, but you have to use that reasonable level of prudence to keep track of what they're doing and ask the right questions that an ordinary person would want to know if it was their money that was being spent. And I think that was absolutely critical. And if you can prove that you asked reasonable questions, you actually listened to what was being presented, and you did what you could to get the information necessary to make good decisions, I think they'll go a long way in a defense if anybody does end up suing the plans.
Okay. So let me go ahead and dive into some questions, and I'll ask each of the panelists one question first, then I'll pause and see if there's questions in the room, and then we'll go to the virtual attendees. And John, let me start with you. You noted right at the beginning that ERISA is 50 years old, that fiduciary responsibility has been around for a long time, and now this topic has popped up. Why now? What's special about 2024? And is this just a quick passing fad, or are we going to see more of this kind of thing going on?
Yeah. So it's a great question. It's unknown exactly, why now. I think part of it is the additional focus on price transparency, the additional data which is available to the enrollees / plaintiffs lawyers for the enrollees. as Stephanie noted, a lot of this had been retirement plan litigation. I think those plaintiffs' law firms are looking for additional money, additional sources of revenue, additional pots of gold out there. And the retirement plan lawsuit, I mean, it's certainly not exhausted, but plan sponsors have gotten a lot better over the past 15 years about focusing on fees, not trying to, trying to make sure that all fees are transparent. The easy cases in the retirement plan area have kind of gone away. And so I think the plaintiffs' lawyers who are well-funded, they have deep pockets, but they're really kind of focusing on this area, I think, for those kinds of reasons. Yeah, so it's interesting. I was talking to an employer client, BHCG member, about this a week or two ago. And the whole concept of the retirement plan area came up, and the in-house lawyer said, yeah, I remember 15 or 20 years ago when there'd be all these kind of hidden, expenses and fees in the retirement plan area. And it took us years to stamp those out, but now they're gone. And I said, yeah, I wonder if 15 years from now, we'll say the same thing about the health plan space. Will we all be saying, oh my gosh, remember 15 years ago, we had all these expenses we didn't know about, and now we've kind of rooted them out, and we got rid of them. Or will it be a passive fad, and we'll say, oh yeah, 15 years ago, we talked about that. Whatever happened to that? I think it tends to be more the former. I think 15 years from now, we'll be like, oh my gosh, our eyes have been opened over the past 15 years, but I'm not sure.
So, Steph, after hearing the presentation, I think given your dual roles, you have the worst of all possible worlds.
Yeah.
Because both a senior HR executive and plan sponsor and fiduciary, and then you're in a health plan who is going to be challenged to make sure that you're supporting plan sponsors as directly as possible. So I guess the question for you is, what does the HR plan sponsor side of stuff expect from the health plan, health operations side of stuff when you talk about really addressing this issue?
Yeah, and then there's like a third role, which is when you come to Centivo as a client through a client success person and ask a question about this, and it comes to me and they say, what can we say? So I was joking with Jackie that one of my roles is going to get one of my other roles in trouble with something I'm saying here probably. So, I think from the chief HR officer perspective, those that are doing the benefits freeze as well. First of all, it's just the awareness of the issue. Like, knowing that it's out there. I think somebody asked me,
I think we've got somebody who's not on mute on the line. Could we make sure that everybody who's on the line is on mute, please?
I think awareness of the issue. I think most people. I think it's me. Picking me up twice with an echo?
No.
No? Okay, it went away.
No.
Okay. I think this isn't something that's out there in the general HR press. Like if you're reading sort of general HR sort of newsletters, I haven't seen it anywhere yet. And so thinking about it from that perspective, I think is something that's helpful to know that it's out there, because if you know that it's out there, you can start to think about it. So as an HR exec, I think speaking to other HR executives, that's point number one. I think in that role too, access to your own data and the information about your fees and what your plan is paying, and can you get that information so that you can exercise your fiduciary duties? So that's probably point number two, is do you have the information that you need in order to fulfill your role and duty? The good news working with a Methodist and a Centivo, which you will. So to put a little plug and part in there. I think when I think about my role at Centivo, where and how we can, speaking to you as clients, there'll be clear areas where you're asking us, can we do this? Should we do this? Do we have to do this? Can't we do this? The stuff that's clear where possible, we try and give you a clear answer. Where there's no question, debate, doubt, it's settled. Some of the lawyers that work for us may be less comfortable with me saying that, but, and then there's another level of where best practices where we can guide you and say, we're seeing this kind of thing, we're seeing that kind of thing. area. And third is where there's evolving areas of new stuff, we're gonna probably tell you, talk to a John. You know, we're not experts in this space. It's too complicated. There's a lot going on. It's not yet clear. You may need to consult with where they are. But issues like these, they're tough. There's not easy answers. And I think what we're finding probably is we'll see in newsletter type things from like law firms and brokers that raise this as an issue. And there's a certain amount of like thrumming that is the word that comes to mind that happens. It's like, you know, this is just like, and then we sometimes tend to overreact in terms of like how much of an actual concern and a risk it is. So John raised the issue of, you know, you're going to get sued. You have personal financial responsibility. Yeah, well, your company has D&O coverage and fiduciary coverage someplace. The likelihood that they're actually going to go after your house and get your house is probably pretty low. But it's, you know, it's an important point. So I guess my other note is don't panic. It's probably the other piece here.
Could I make a comment
Yeah.
on that though? But what you're, so I used to live in that rural right on the property and casualty side. And what you're seeing is the availability of that type of coverage is now becoming less available. And if it's available, it is through the roof and what they're charging for that coverage. And this is going to have an impact on that.
Yeah, that's probably true. That's probably true. Yeah.
Sorry.
No, it's a good point.
That's a good point. Paul, I'm going to turn to you for a second. You know, other than the fact that the J&J lawsuit showed that Navitas is walking on the side of goodness and light, so I'm delighted to hear that. But the, you know, whole approach that Navitas have taken, putting a premium on full transparency, is something that provides great information for plan sponsors, but as John noted, also has the two-sided risk of now everybody knows everything, and so they can pick at every little decision. You know, Navitas has to make decisions as to how it creates the opportunity to have a financial optimization model. You're doing negotiations with the, you know, lots of manufacturers and wholesalers to get the best price for drugs, and some of that includes trade-offs. How do you make that kind of information available to plan sponsors so they know the approach you're taking? What do you think is an appropriate level of understanding at the plan sponsor level? And you know, how much do you have those kind of direct discussions with plan sponsors about decisions that are being made on behalf of the PBM to really serve the employers?
I do want to say thank you for pointing out that we're on the side of all things good and right. That sounded great. Navitas was founded as a pass-through transparent PBM, and we held to that mission across our history. We do what we can to make sure that employers and plans that are our clients have all the information they need to make good decisions. So we have reporting tools, we provide claims extracts where appropriate. We walk through how we set up the formulary, the list of covered drugs. When we provide a proposed formulary, we provide our clients with the opportunity to make changes to that. And some of the things you mentioned as far as the trade-offs come in which drugs end up being covered. And some of that, again, will be if we had and getting a little bit of feedback or something, if everybody can be sure that they're muted online. But when we work with our plans, we provide recommendations. But from our perspective, as a pass-through transparent entity, the plans are the ones who really have the opportunity to make the final decision, and it's their money. We do not charge any spread on claims or on any of the rebates that we get back. And so what we do is we advise our plans what we think is a good option. Certain plans will make different decisions. They'll make decisions that they want to have a particular drug because it's commonly used and they don't want to disrupt their members. And that costs a little more sometimes. Some plans will make decisions that they want a drug that is a brand drug versus a generic because the brand is offering such high rebates that it actually comes in cheaper than the generics. And that's a trade-off that we have discussions about. And each plan has that opportunity to work and customize their
formulary as needed. We also have a lot of expertise in our P&T committee that sets the formulary for our standard setting plan. And so as we walk through this with plans, we make every opportunity to give the plans the information they need to make the decisions and support them in making those decisions across the scope of their benefits that they provide on the pharmacy level. Trying to remember all of that. You had a very long question, so I'm trying to remember the last half of the question, if you wouldn't mind repeating it.
Well, I think that you were going down the right path, which is for an employer to really understand what you have done in making some of those decisions. There's an awful lot for them to unpack, and frankly, it requires a level of expertise that most employers don't have. So how can they really evaluate the kind of pricing decisions that you've made, and when they bring in outside advisors to do that, are you open to having those direct conversations with the various entities about how you've made those kind of pricing choices?
Yes, and we absolutely are willing to have those discussions where employers are bringing in their outside consultants in these circumstances. And we have had numerous circumstances where we've dealt with outside consultants and made changes to the formulary that's implemented for those specific plans. So we're very open to working with other parties and taking different approaches. We have some clients who want to do things that are somewhat experimental in terms of changing things up, and we're very open to doing that where appropriate and supportive, but also provide the background information as to how our P&T committee came up with the decisions they did.
Okay. Let me stop and see if there's any questions in the room here. Go ahead, Pam.
Hi, Pam Hannon from GE Healthcare. One of the questions I have is around the rebate and when your participants are paying a percentage of cost. So I go to get my Humira and I wind up paying 20% of the full cost, yet the rebate comes back to the company. How is that? What fiduciary risk do we have for that? Is that okay? Because I feel like I've paid more than perhaps my share.
So I can take a quick step on that. If you guys want to respond. The question as to whether it's okay or not is a question of how plan resources should be allocated against member resources, and that's a somewhat of a judgment call, because there's always going to be a copay component of most plans, and so when a rebate comes back to the plan, that should be used to offset other plan expenses or other items, and so there's a good question as to whether or not the fact you needed X definite, in your example, that you needed X, whatever the drug was that had a large rebate, that also means there was probably a very large expenditure that went along with that rebate. And so someone who didn't get sick or didn't have an illness would have paid in a premium and got nothing back, but also not gotten much of a benefit. So there's a bit of a balance going on to say, well, if you're taking a huge expenditure and a little bit of it comes back, or a chunk of it comes back, isn't that really just offsetting the overall cost? And the rebates issue is a really tough one, because various states have taken the approach of saying you have to credit the individual member with copay assistance that comes in, and we sort of think that as a form of a rebate, like a coupon. You have to treat that as if it was paid by the member for the accumulator dollars that come through the plan. So counting that towards the maximum out-of-pocket that an individual would have. The other piece of that, when you look at it from the plan's perspective, the member didn't pay that at all. And so there's no incentive for the member to manage the amount they're spending, and there's no cost to the member. And so the drug manufacturers are really making out like bandits on that, because they put the money in to get the member to act a certain way, to use a particular drug, but the member has no out-of-pocket there. And so that's an area where we're seeing regulation at various states and a patchwork, and then the Department of Labor comes out with rules that are actually counter to what state law is. So Illinois, for example, requires individuals to be credited with that amount, whereas the Department of Labor is saying that because it wasn't directly paid by the individual, that takes away the ability to count it
for having met the individual's deductible amounts at high deductible health plans. So there's a lot of complicated factual components to that. And at the end of the day, there's a bit of a judgment call that plan fiduciaries need to make when thinking about what should the COPA be, how do they deal with those rebates. And as long as you're going through a reasoned process and saying this is the judgment that the plan should be making based on a series of values, I think that you should be okay. I'll ask my colleagues to weigh in there.
Yeah, it's hugely complicated, and I am not an ERISA expert, and I am not even a benefits expert. So let's kind of like lead with that. And I didn't start practicing law again at all until about a year ago when I came out of a 20-year retirement. But in reading the commentary to prep for today, one of the things that my spidey sense went off on, there was a lot in the complaint that talked about the cash pay price. And I think all of us as members in the room can think of times where we've gone to the pharmacy or had something that we wanted to buy. And if we're inside baseball as benefits people, we have this like weird sense that like we could pay this cash versus like what it costs under the plan. But if I pay cash, it doesn't go against the copay. I'm wondering, so there's something about the whole pharmacy space and the complexity of the pricing and the incentives that are set up that I think is making us more like ripe and complicated. It's exactly like the fees in the retirement era where they were complicated and not easy to figure out. And I think that makes this a right area because it's very, very, very hard to understand when you think about like what drug versus copay assistance versus rebates versus cash pay. And I wonder, I would hate to read this into existence, but will there be something that the Department of Labor does in terms of this cash pay issue? And saying plan sponsors, your members are acting in their own best interest, which is in the best interest of the plan. And so you need to be counting cash payment toward the copay and take the whole like other mess out of it. Like, I don't know.
You know, there is regulation that's out there that are anti-gag clause requirements.
Right.
So if individuals go into the pharmacy, and different states have different rules, but in most places, if you go into a pharmacy now and you ask, what's the cash price? What's the usual and customary UNC price? There is an obligation for the pharmacy to tell you, and the plans should not be able to block that sharing information, which is a lot of what happened in J&J, that if somebody walked in and said, you know, this is $1,500, what's the cash price? And it's 10, they'll say, well, I'll pay 10, because it's,
Right.
you know, it's crazy to have that sort of egregious situation, and that's the type of thing that I think leads to lawsuits.
Yeah, very much so, very much so. Yeah, some of the commentary talked about, especially carve out, you know, and those types of strategies here as well that you need to be thinking about. It's just, it's complex. It's complex, which takes us back to one of the points that John made is like, maybe and it's, I don't know how many of you guys are in small HR departments of like 3 to 5 to 7 people total. And I hate to even say this, but, you know, can you have a quarterly meeting? Did you set up a formal benefits committee and have a quarterly meeting and just take basic minutes of, we talked about this, we decided this. We talked about this, we decided this. Because that would be a significant assistance because this is so complicated. And I think the answer of what is right and what is prudent, the courts will have to say, to your point, John, that the outcome is only 20%. The substantive piece, the procedural piece is just, were you acting like a fiduciary? Were you thinking and thoughtful? Did you have a process? Did you write it down? Those go a long way in terms of protecting you from house getting taken or whatever John's trying to freak us out by.
I'm sorry. I agree with what you're talking. If you're looking for additional guidance on that rebate issue too, in the early 2000s, the Department of Labor issued guidance in the demutualization context. A lot of insurance companies demutualized, and that resulted in a refund back to the employers. The demutualization guidance there was, if you look at that ratio of how much were employees contributing, let's suppose it's 20%, how much was the employer contributing, let's suppose it's 80%, then 20% would be plan asset according to the you have to use it to benefit plan participants and beneficiaries, which I think what Paul said. Same concept came up in ACA with the medical cost ratio. These now are rules where insurers, if they made too much money, had to refund money back to the plan sponsors. Again, the DOL guidance came out very similar. If you look at it on a proportionate basis, the sliver that is plan assets has to use the benefit plan participants.
Did we answer your question?
Yes, thank you.
Okay.
Can I make a comment? So my name is Mosa. I am not an attorney, and I am not an ERISA expert. I am boots on the ground. I work for a rheumatology practice. I'm also a patient advocate, and I also volunteer with the Coalition of State Rheumatology Organizations in their payer response team. So it was mentioned or asked, how are people becoming aware of what is happening here? I have a list of 6, at least, and in no particular order. Number 1, the efforts of BHCG in trying to educate employer groups on the shenanigans that are transpiring in non-transparent BUCAs in the non-transparent PBMs. We also have a gentleman by the name of Matt Ford, MATTOHRT. Matt wrote a book. It's called Don't Feed the Beast, and it's for employer groups, self-funded plans. Grassroots efforts has started in Wisconsin for at least a couple of years, and he is now in 10 states and counting. As of this week, he's in the state of Virginia. So things are happening. There is a national summit of advocates where we have UCAS, we have PBMs, we have patient advocates like myself, and many other people that are interested in all of these, typically access, transparency, or cost control. This year is going to be in Las Vegas. It's going to be 1,000 people. And Matt will be also presenting. The summit is so excited that they are getting 1,000 books. I will be stuffing those for all the attorneys and the people attending the summit to enhance knowledge. Mark Cuban, who hasn't heard of Mark Cuban, guys? He's bringing in his own, right? Everything in house, getting rid of the non-transparent BUCAs. And he has a different PBM. It's not Navitas, but it's someone else who's also transparent. And he's starting to talk a lot about this, not only in favor of independent pharmacies that are being decimated, but also what happened to him as a self-funded employer himself. So he got taken. And his story is way out there. And obviously, he has an audience. You now have the lawsuits. Wondowski, you have the Mayo Clinic lawsuit, and the attorneys are advertising. Let's get employees involved in this. Then you have providers offices like mine. I work for a solo rheumatology doctor. He's the last of the Mohicans here in Milwaukee. He does his thing, and I do my thing. This is what I do. And through the CSRO, we literally talk to self-funded employers and educate on all of these things. The non-transparent brokers, the non-transparent BUCAs, the non-transparent PBMs, the lawsuits that are coming out there. I mean, it's all happening. Last, you mentioned Yusimry. So being in Humira.
Yeah.
So being in rheumatology, right? We are trying to figure out why Humira and not something like inexpensive Yusimry. You can get that from Cuban for less than $600, not thousands and thousands and thousands of dollars. So why aren't self-funded employers looking at some of these biosimilars that are a heck of a lot cheaper than the number one selling drug in the country, work extremely well, but they usually try to keep biosimilars from getting into the market by changing formulation, by making it non-stinging, by changing this, by changing that. I mean, here we are today. So also one last anti-gag clauses. at the pharmacy level, right? It happens at the physician's level too. I am looking at those contracts for my clinic, and I have to tell you, when a buka overpays, and typically, because I do the billing also, my hands are all over the place here. When I do the billing and I determine that there has been an underpayment, I have to go and appeal that. They make me go to the next process. And when I appeal it, many of the non-transparent bukas will reprocess the claim, creating an overpayment because they're not counting what that initial underpayment was. So at the time of a refund, I do not wait for them to ask me for a refund. I literally say, where do I send it? Here's a check. And by the way, I will be contacting the self-funded plan to let them know that this money is being refunded. Because what I have been hearing from other attorneys and other more transparent brokers and whatnot is that when physician practices are issuing these refunds back to, not really the self-funded plans are being made aware. So we don't know what's happening with this money that we're getting, to send back. But this is what I say to the people on the other end, and all you can hear is nothing on the other end. It's not an answer that they expect. Last but not least, when I have to advocate for my patients and I have a denial for care of services on self-funded, the very first thing I do is I ask my patient to provide me with an SPD. I read those babies. I'm not an attorney. I'm just, boots on the ground, baptism by fire, guys. I read those plan documents. I'm here to tell you that oftentimes these non-transparent bukas are not applying what it is on the SPD. What they are applying is what they have on national clinical medical policies. One size fits all. That's very dangerous. I have other colleagues that are also as vocal as I am in other parts of the country, and they are getting buka contracts that specifically state that unless they stop going to the third, the sponsors, the plan sponsors, all of our grievances, we have to deal with directly with the buka. We are not allowed to call to you or any one of you to let them know that there's something cooking, that there's something going on. If we do, they're threatening by terminating our agreements and kicking us out of whatever. Talking about a gag clause.
Thank you for those. Let me see if there's any questions from the remote.
Before, any comments from the three panelists on what was just verbalized?
Sure, I'll actually respond to a couple of those items at least. On the Humira biosimilar statement you made, I think that was definitely a case maybe a year ago or so, as far as the lack of a biosimilar strategy. As new biosimilars were coming out, the cost was actually higher than Humira for a little while. Now that's definitely not the case. And so at least in Navitas, we have a biosimilar strategy that certainly takes into account the amount of rebates you can get with Humira versus the generic cost of the biosimilars. And so we are working with our clients to establish formularies that have the lowest available cost for clinically appropriate drugs. And that's always been our approach. Secondarily, I wanted to address the issue you brought up about Mark Cuban. And it's an interesting approach that he has to manufacturing generics and other drugs where appropriate. We actually, Navitas, invested in a company called Civica and Civica Script, which manufactures generic drugs as well, in an attempt to make sure that there are supplies available. So what we're seeing in the marketplace right now is that there are a lot of generics that are becoming unavailable because the manufacturers go out of business, or there's one manufacturer and they jack up the price, like we saw with the EpiPens not too long ago. So along with other founding members, we invested in a company that actually does manufacture drugs where appropriate to help make sure those are available in the marketplace and that the costs stay low and reasonable. So there's much more being done in the marketplace, but it's not always as high profile as Mark Cuban.
Right, and with regards to the biosimilars of Humira, as you know, when they came out, some of those have two different NDC numbers. The NDC numbers, for those who don't know, is like having your social security number, right? It's unique. And one was priced dirt cheap, 75, 80% or whatever less. And then the other one was what, like 5% or 10% of Humira? When those reps came to my office and they said, we're on formulary for this one, we're on formulary for the other one, I said, which NDC? Out. It's not the one with the lowest price. I don't want to even hear about it.
Yeah, the hard part is that the lowest price for whom is really the question. Is the lowest price for the patient? Is the lowest price for the plan? Is it the lowest price overall? When you incorporate those rebate dollars back in, you may have a much lower price overall because the manufacturers are playing games with the rebates. And they generate high rebates that really drop that price for the plan. But then depending on the structure of the member, they may end up paying more or less. So it's a very challenging game to figure out if you're not familiar with it.
Come to my office.
Yeah. So, any questions from those attending virtually? If you've got a question, please come up mute and identify yourself, and then go ahead and ask your question, and I'll try to referee from this side so we don't have people talking over each other. Questions from the virtual audience?
Hi, can you hear me?
Yes, we can.
Okay, hi, I'm Dr. Madeline Feldman. I'm a rheumatologist practicing in New Orleans and am actually Vice President of Advocacy and Government Affairs for the Coalition of State Rheumatology Organizations. And we do have an employer toolkit, particularly for the autoimmune inflammatory diseases, because they may be 1 or 2% of the population, but tend to fall anywhere between 20 and 40% of the drug spend for self-insured employers. And there are a number of issues that we've run into where we are trying to get information perhaps from one of the big 3 PBMs. For example, how much are you going to charge the plan for a drug that could be bought and billed through the physician, but is being forced to be run through the specialty pharmacy? And in those cases where we've actually gotten the receipts, it is about 3 times more through specialty pharmacy. And I have spoken with the global health benefits of one of the largest international companies in the United States, who basically said, well, we're not going to have Express Scripts tell you how much it is because we trust them to give us the lowest price. He said, we have contracts. And I said, can you define for me what the lowest net cost is? And it's silence. So in terms of trying to help our patients and the plan meet their fiduciary responsibility, oftentimes we are required to, we run up against a brick wall. And they say it's proprietary. We quote the Consolidated Appropriations Act of 21, and there's like dead silence. So that's number one. Number two, what's out there is, oh, employers are addicted to rebates. We hear that over and over and over again. But when you take the Humira, someone asked me to speak to a large company that spends $50 million on Humira, and their consultant said, don't go to a biosimilar. So even if they got 50% back, and it only cost them $25 million a year, at $600 a month, the Yusimry, for example, comes out much, much less. So the excuse of the rebates bringing down it to the lowest cost, when you're talking a $7,000 a month drug, even with a 50% rebate versus $600. So anyway, my question is, do we have any standing to force a PBM to give the specialty pharmacy total price to either the plan sponsor? I know there's an issue between the granularity of how much transparency there is, but can a plan sponsor force their PBM to say how much it would cost through their specialty pharmacy?
So I'm going to ask John to answer that question first, and I'll ask Paul to talk about what Navitus does.
Yeah. So great point, Dr. Feldman. In terms of the disclosure of some of this information, so we talked about how the CAA has that gate clause provision where plan sponsors are supposed to be able to get access to a lot of claims information. If plan sponsors can get access to it, they should be able to pass along to others, like maybe your organization. The exact scope of the gate clause is a little bit unclear, and we have seen some of the larger entities push back against it. Right now, Elements, formerly Anthem, is in a lawsuit out in Connecticut. Bricklayers Local Number 1 out in Connecticut has sued Anthem Elements for access to their data. They have a self-funded health plan. Elements is pushing back very strongly, saying, no, we know what the gag clause says. The gag clause applies to you. It doesn't apply to us. And so if your contract is not compliant with the law, that's your problem. If you want to negotiate it with us, we're happy to talk to you about it, but we're going to require restrictions on the data. We're going to put up roadblocks. We're not going to let you give it to your consultants. So the bricklayers, Local Number 1, are fighting a good fight from an employer plan sponsor perspective, trying to say, nope, we get access to our data. But something which seems pretty clear under the CAA is being litigated to the death right now over this issue.
So I think under the reporting requirements of the CAA, there should be a way to mine the data to find it. But for most of the requirements, it's getting very deep into people's websites or in difficult ways where you can't actually find it in a way that's useful. What we found is that a lot of the plans and a lot of the PBMs have a plan finder tool, which allows members and others to look at what individual drugs cost through their websites. That's probably the best opportunity to force, to try to get that information. But on the specialty side, it's particularly difficult. Just as a counterpoint, what we do is we have a wholly owned specialty pharmacy called Lumicera, and what we do is we set the pricing through pass-through methodology at the specialty pharmacy level. So we actually have the price we pay with a markup, and then we provide that information to our clients so that you can get that information. But I know we're not the norm.
Additional questions virtually?
So I know we've only got a few minutes left, and because I can't help myself as a recovering consultant, I will actually throw a couple additional thoughts in there. There were certain words that were used in a number of those answers and a number of the pieces of presentation today that I would suggest you as plan sponsors be very aware of when you are looking at the service providers you're working with. When you hear the words proprietary data or data use agreement, you might want to start screaming. Those are the ones that tend to be the ones really used to hide as much information as possible. The world is working towards far more transparency. There are a number of organizations, and you have two on the panel here between Navitas and Centtiva who are firmly committed to the basic foundation that employers' data is their data.
And completely transparent.
And I think that, as the push from the employer community continues along that side, those organizations that are not committed to that, I think, are going to be brought kicking and screaming to it. But you as employers have a great deal of power influence in that, and I think we've underutilized that over time. So those are some real opportunities. I'm going to ask one of the questions that was sort of an underlying one in the J&J lawsuit, which is sort of the role of some of the benefit advisor solutions and coalitions and things like that have been developed over time. Many of them were developed by the consulting houses or the brokerage community to say we've got a better solution than the off-the-shelf PBM solutions, and yet they, almost by definition, create potentials for conflict of interest. And I'm going to throw it to John. John, what do you think? Should those exist? What's your sense around that? Is it something that employers should be using? Is it something that employers should be staying away from? What's your thought?
Yeah, I think that in general, employers should be aware of the potential for a conflict or the actual conflict and keep that in mind and go through that kind of procedural due diligence that we talked about. Just because your consultant is recommending their own product, go kick the tires with somebody else. Maybe go to a different consultant who has their own product. Don't just blindly follow, I guess, your consultant's recommendations, even though I'm sure you trust your consultant. I'm sure that they give you great services. Again, document your process, follow your process, kick the tires with other vendors.
Good, Paul.
Can you comment on the funding behind the J&J lawsuit, the Advocate Aurora lawsuit, the Aspirus lawsuit? Because I think it's something that everyone needs to be aware of, and then who the law firm is that's taking the charge in this. If things are going to change, it needs to come through those types of organizations.
Yeah, it's a good awareness point for all of you as employers and plan sponsors. There are a group of stakeholders and really advocates and frankly warriors out there who have a very strong opinion as to how we're going to change healthcare. One of those is an organization called Arnold Ventures, which has been funding a number of the lawsuits that are being undertaken, and they tend to use Fairmark Partners as their legal firm to support a lot of this. Jeff's comment is right. They're the common thread between the J&J lawsuit, the anti-competitive complaints against Advocate Aurora and against Aspirus, have been the involvement of the Fairmark law firm and the Arnold Ventures funding. And, our expectation is that we will see more of this, and it is shining a light on some of the practices that feel certainly uncomfortable and have to be evaluated objectively and looked at within that context. But our expectation is that there's more of this coming. So all of you who've had the patience and good sense to spend your hour and a half with us today in hearing some of these things, I think we will do our best to keep you aware of those things. But this is clearly something that is an emerging element in the healthcare space. It will require all of us to raise our game a bit in terms of some of the understanding of the inside baseball. But a lot of useful stuff coming out, and as we all know, the U.S. healthcare world is pretty broken. But there are a lot of pieces being put together to try to fix the system. And so some of these play right into that. So with that, Jeff, any last comments before we let everybody go?
Once again, Jennifer, May 14th is the next Deliver and Value Series Symposium on obesity. We have a summer event on June 18th. Keynote speaker is going to be Ashok Subramanian, the CEO from Centivo, and several other national speakers. And let me back up, in that obesity group, the main speaker is the department chair from Freighter, and I just don't remember her name. And then we have two pharmacists that are going to join us from Navitas, and then we also have an individual from Novo Nordisk that's going to be in the panel too. And we're really going to panels away from presentations. And then again, June 18th, and look for who the national speakers are for that event. And then finally, some fun. Our golf event is on, any idea?
August 15th.
15th. And you're all invited, so please come and join us.
And just a quick.
And we support every time that we may at that golf outing goes to the Sojourner family. So everything goes there.
And
we don't keep anything.
Just a quick reminder for the BHCG member employers, these benefit forums are venues for you. So if you have ideas that you'd like us to include in future benefit forums, please go ahead and shoot a note to Jeff and Jennifer, and we can make that happen. So thanks everybody for your
and once again, I'd like to thank Paul and John and Stephanie for joining us this afternoon, and Dave for this morning, and Dave for moderating. and for all of you for taking time out of your incredibly busy days to join us. So thank you very much.
Thanks, folks. Have a good day.
Thank you.